Hello, everyone, and thank you for joining me for this training on temporary protected status called TPS, specifically for Afghans. This is a 101 level training that's going to provide a basic overview and explanation of what is temporary protected status and some special considerations for Afghans. My name is Stephanie Baez, and I am pro bono counsel with the American Bar Association Commission on Immigration, and I will be guiding you through the training today. Our roadmap, first we're going to discuss what is TPS and give an overview of what the status is. Then we'll talk about the eligibility requirements, bars to TPS and special considerations for Afghans, employment authorization and filing fees as those pertain to TPS, and then some other considerations such as processing times and how TPS interplays with other immigration statuses. And finally, we'll conclude with some common FAQs. So to begin, let's jump into the TPS overview. What is temporary protected status? TPS is a short-term benefit for non-citizens who are not able to safely return to their home country due to certain conditions or circumstances. Some examples of why a country might be designated for TPS is if there is an ongoing armed conflict, such as a civil war, an environmental disaster like a hurricane or earthquake, or other extraordinary temporary circumstances, such as an epidemic, that make it unsafe for nationals to return to that country. A country, to become a TPS designated country, it must be designated by the Secretary of DHS after consultation with the Secretary of State. For a country to become designated for TPS, first, the Secretary of DHS designates the country as being eligible for TPS, and then USCIS issues a notice in the Federal Register. And that notice in the Federal Register is the notice that makes TPS officially available for applicants from certain countries. It has information on specific dates, the dates of the TPS designation period, and information on how to apply and where to mail paper applications. To apply, a TPS seeker must file a Form I-821, and they may also apply for employment authorization, which we also refer to as an EAD or a work permit, by filing Form I-765 with USCIS. And those two forms can be filed concurrently. TPS is typically granted for an 18-month period, and the expiration date is the same for everyone from a given country, regardless of when they apply. So the expiration date for the TPS designation period is the same. There's a certain designation period that exists, and people can apply within that period either earlier in the designation period or later in the designation period. But regardless of when they apply, the expiration date will end when that designation period is over, which is the same for everyone from a given country. But prior to the end of the designation period, 60 days prior to the end, the Secretary of DHS will determine whether to extend, redesignate, or terminate the temporary protected status. Extension means that TPS holders who have TPS can renew their status for another designation period. Redesignation means that additional non-citizens can apply. People who maybe didn't qualify for the initial designation period now might be able to qualify for the redesignation period, and they can apply even if they weren't prior TPS holders. Or it is possible that TPS status would be terminated, meaning that benefits expire for people from that country. Now let's take a look at the TPS eligibility requirements, and specifically as they pertain to Afghans. First requirement is that an applicant must be an Afghan national. They have to be a national of the TPS designated country, which in our case today is Afghanistan. So an applicant must be an Afghan national or a stateless person whose last habitual residence was in Afghanistan. The second requirement is that an applicant must have had continuous residence in the United States since March 15th, 2022. This March 15th date is specific to Afghan TPS, since that's what we're discussing today. The continuous residence and continuous physical presence dates that I'm going to be discussing in this training are different depending on which country we're talking about. They're different depending on the different TPS designation for the different countries. But today, since we're talking about Afghanistan, the dates we're going to focus on are the ones that relate to Afghan TPS. So for Afghans, continuous residence must exist since March 15, 2022. And we'll talk about what that means in further detail later in the presentation. An applicant must also have had continuous physical presence in the United States since May 20th, 2022. And again, we're going to talk about what this means and how it's distinct from continuous residence. And finally, the fourth requirement is that the applicant must apply within the initial designation period, which for Afghans is until November 20th of 2023. The Afghan designation period is from May 20th of 2022 through November 20th of 2023. Some of the benefits of TPS. First and foremost, a TPS holder is not subject to immigration detention or removal, meaning that they do have a legal status that's conferred on them to stay in the United States. So they are not subject to detention or removal while they have TPS. They are also eligible for an employment authorization document or a work permit, in other words, so that they can work during their TPS status. A TPS holder is eligible to apply for a travel authorization, which is also called advanced parole. And that travel authorization, if they receive permission, they're able to leave the United States and return back to the United States without any issues if they have that advanced parole. And having TPS does not bar a non-citizen from seeking other forms of immigration relief. So someone who is seeking or has obtained TPS can also apply for other forms of immigration relief, such as asylum, or they may have a tourist visa or a student visa. But they need to be aware that they need to follow the requirements to stay in status for all of their various immigration statuses, which might be different than the TPS requirements. But TPS itself would not bar someone from filing for other types of immigration relief. And there are some limitations to TPS. First and foremost, it's right there in the name that TPS is a temporary status. It's only for a short duration, generally lasting for 6 to 18 months for TPS holders. The current TPS for Afghanistan designation expires on November 20th, 2023, as I mentioned. So depending on where someone is at in the designation period, if they're applying closer to November 20th or further away from November 20th, that will determine how long they have TPS, but the expiration date is the same for all. We should know by September of 2023 whether TPS for Afghanistan's will be extended or redesignated, or whether it will be expiring. TPS does not offer a pathway to residency, such as a green card, and does not offer a pathway to citizenship. Additionally, there are no follow to join opportunities with TPS, meaning that the TPS holder cannot bring family from their home country to join them based on having TPS status. And similar to that, there's no derivative status available for TPS. That means that each individual family member must submit an individual application for TPS, and their individual application will be considered on its own strengths and merits. So for example, a minor child needs to apply for TPS regardless of how young the child is. The minor child needs to submit their own application, and they cannot be a derivative of their parents' applications. Similarly, a spouse, if a married couple, let's say one member of the couple is an Afghan national and the other one is not, only the Afghan national is potentially eligible for TPS. The person who is not an Afghan national is not eligible despite being married to an Afghan national, because we're looking solely at individual applications. Next, let's talk about TPS eligibility requirements. To begin with, just a snapshot of TPS for Afghans. The registration period for Afghanistan is between May 20th of 2022 through November 20th of 2023. That is the registration period where people can apply for TPS. And TPS was designated for Afghans. Per the Federal Register notice, there's a quote here for the reason of why TPS was designated. But basically, an assessment that since the Taliban took over, there has been a humanitarian disaster in Afghanistan, including economic collapse, a crumbling healthcare system, severe food insecurity, and significant human rights challenges that make TPS a necessary designation for Afghanistan. And the specific requirements for Afghan TPS, again, the dates are here, that someone must have continuously resided in the United States since March 15th, meaning that someone who entered the United States after March 15th is not eligible for TPS. Those are firm deadlines. And someone must be able to show continuous physical presence in the US since May 20th of 2022. So to file for TPS, you need to have the TPS application form, which is the I-821, plus supporting evidence that shows the applicant meets the eligibility requirements for nationality, continuous residence, and physical presence. So let's talk about those a little more in depth and what type of supporting evidence you would need to file in addition to the form I-821. First, we discussed that to be eligible for TPS, a TPS seeker must have the requisite nationality, meaning that they are a national of the TPS designated country, such as Afghanistan, or they're a stateless person whose last habitual residence was in that designated country. To prove nationality, an applicant can show their passport, showing that they're a national, a birth certificate showing that they were born in Afghanistan, or another national ID document. Passports and birth certificates are the strongest if they have that evidence available. If the person is stateless, then they need to rely on some secondary evidence, such as a sworn affidavit showing that they resided in the designated country and that was the country of their habitual residence. The next eligibility criteria is continuous physical presence in the United States. And like I mentioned, that requirement is that you must actually be in the United States for the period of the country's designation period. So to show this, it's important to show date of entry to the United States. To show that someone has been here since the physical present deadline, we need to show what day they arrived in the United States. So important evidence to show proof of date of entry into the US include a passport entry stamp or an I-94 entry record, and those would be available to non-citizens who entered the United States lawfully. But for someone who entered without permission, they might not have a passport stamp or an I-94 because they came in different manner. For those individuals, they may have documents that were issued by immigration court, such as detention records or notices to appear from immigration court, or they're going to need to submit any other documentation that falls under the continuous residence category, which we're going to talk about in just one moment. And that continuous residence evidence can also help support their claim that they've been continuously physically present in the United States during the time period required. But if it exists, the proof of entry evidence really is the strongest, such as a passport entry stamp, an I-94 entry record, or documents from immigration court showing that someone has been referred to immigration court. In addition to continuous physical presence, we need to show that someone has continuously resided in the United States during the designation period. And continuous residence really establishes that someone has an intention to stay in the United States and reside here, as opposed to the physically present requirement. That could apply to someone who's just visiting. Someone who is just planning to pass through the United States on a visit would be physically present in the US, but not actually reside in the United States. So that's how the two different prongs, although similar, there's a slight difference between the two, that we need to be able to prove first that someone was actually physically present in the US, and also that they continuously reside in the United States, meaning that they have been here, set up a home, set up a residence. It is worth noting that someone can leave the United States for a brief, casual, and innocent absence, and a brief trip abroad would not necessarily be fatal to their claim for continuous residence, but it is something to be considered and weighed for how long they left and what was the reason for why they left that might impact their TPS eligibility. But to show that someone has been continuously residing in the United States, they need to show the following types of evidence. Documents with their name and their date that establish a US location. Receipts are often very helpful evidence in this category. And one example of what would be a helpful type of evidence or receipt might be a receipt from a library showing checking out books from a library that shows the applicant's name as linked to the library card. So the receipt shows the applicant's name, it shows the dates that the books were checked out, and it shows the location of the library branch inside the United States. So that receipt would meet all of our criteria that we have client's name, date, and US location. But conversely, something that is not helpful would be a receipt from a grocery store. Even if that receipt might show a grocery store within the United States and groceries were purchased on X date, it won't have the applicant's name on it. So it doesn't specifically link that person to being in the United States. So that is not helpful or persuasive evidence for the continuous residence requirement. The most common types of evidence that we seek and that we see and that is helpful for this prong include employment records showing that someone has been working in the United States, rent receipts showing that they're paying their rent, lease documents, utility bills, mortgage payments if they're paying mortgage, school records from any schools that they or their children are attending in the United States, hospital or medical records showing treatment or hospitalization in the US, or attestations by church or union or organization officials who know where the applicant has been residing and who can issue a sworn affidavit or attestation to that person residing in the United States. All of the supporting evidence that is submitted to support the TPS application must be in English, or if it's in a foreign language, it needs to be translated to English and accompanied by a certified translation. That does not mean a professional translator. It doesn't need to be someone who's paid for or who translates for a living. It just means that the individual who's signing the translation document needs to certify that they are competent in English and in the foreign language and that they translated the document to the best of their abilities. But documents, for example, a birth certificate that is in a foreign language needs to be translated to English. Anything that is in the foreign language needs to be in English before it can be submitted as evidence to support the TPS application. So now we're going to move on to discuss bars to TPS and some special considerations for Afghans as pertaining to those bars. Bars to seeking TPS include the conviction of any felony or 2 or more misdemeanors in the United States that would make someone inadmissible under certain immigration codes in the INA. Some of these inadmissibility grounds are waivable, and to waive them, a form called the Form I-601, which is a waiver of inadmissibility, could be filed to waive someone from being barred based on these grounds. And the waivable possibilities include bars based on prostitution, certain controlled substance violations, drug abuse or addiction, fraud, or smuggling. But there are other bars that are not waivable, such as crimes involving moral turpitude, multiple criminal convictions, drug trafficking, security threats, terrorism, adverse foreign policy considerations, or participants in Nazi genocide. Those bars are not waivable. We suggest for applicants who are facing any of these potential bars or might need a waiver of inadmissibility that they work with an attorney one-on-one to have a consultation to see what needs to be done in their case to make sure they are TPS eligible and how they could properly file a waiver. In addition to the inadmissibility grounds, there are also mandatory bars to asylum that are also bars to TPS. And those bars include having participated in the persecution of another person, which is also referred to as the persecutor bar, convictions of particularly serious crimes, And reasons to believe a non-citizen is a danger to the US, or, this is an important one, having engaged in or incited terrorist activity. That's an important one for Afghans, and I'm going to touch on it more in just a minute. And another important one is having been firmly resettled in another country prior to arriving in the United States. Again, that's an important one that is relevant to many TPS applicants from many different countries. So I'm going to touch on that one in more detail in just a moment as well. Actually, right now, I'm going to touch on that one, firm resettlement. So this is a really important concept to understand for TPS applications. Firm resettlement occurs if, before arriving in the United States, someone entered into another country or in that country received an offer of permanent residence status, citizenship, or some other type of permanent resettlement. And despite the way that that language is written, an actual or firm offer of permanent resettlement is not required. So basically, it's just if there is an existence in the country that a foreign national could obtain permanent residence, that could be sufficient to meet the requirement of an offer of firm resettlement. So by virtue of being in a country where they could potentially obtain status, that could trigger the firm resettlement bar. However, there are some exceptions to firm resettlement that are very important in the TPS context. The first is if you can show that entry into a third country was a necessary consequence of a flight from persecution, and that the TPS seeker only remained in the country long enough as was necessary to arrange onward travel and did not establish significant ties in that country. That is one exception to firm resettlement. So basically, if someone was in a country, but it was for a short time, they were there only as long as they needed to arrange their travel to the United States to keep the onward travel here, and they didn't establish significant ties in that country, then that is one exception to the firm resettlement bar. And another exception is that if conditions of residence in the third country were so substantially and consciously restricted by the authority of that country that the applicant could not actually be considered resettled, that's considered an exception. Meaning that if there are, for members from a certain nationality in a third country, if there's no meaningful employment opportunities, they are discriminated against such that they can't get housing, that there is other discrimination that prevents them from being able to meaningfully participate in society, or that they're not able to be safe in that country because of discrimination or persecution within that third country, then that's another reason to argue that they were not in fact firmly resettled, because the conditions were so restricted that they can't actually be considered to have been resettled there. So with all of that law in mind, what are some takeaways for TPS? First, that layovers and stops between an evacuation from a country like Afghanistan and arrival to the United States, that doesn't really create a problem. If our applicant had to stop in many countries, if our applicant stayed in lily pads in different countries on their way to the United States, that's going to fall under one of the exceptions to firm resettlement and not create a problem for their TPS application. But if we have an applicant who traveled to a country where they held status or officially applied for status, that might be a little bit more of an issue or a challenge. And in those cases, we really need to analyze, was the status permanent? Was it renewable, or would it expire and it was temporary? And would the applicant have actually been safe in that country? Or would their conditions of life be substantially and consciously restricted? So those are all things to keep an eye out for firm resettlement. And in the TPS application, there are questions that ask about other countries that the applicant holder has been in, or the TPS seeker has been in. And it's very important that the applicant answers those questions truthfully about what countries they've been in. And there's an opportunity to provide further explanation regarding their time in those countries as part of the TPS application. We have other training videos that cover how to complete the forms for TPS, specifically for attorneys who are helping in a volunteer clinic setting. And those are available on the ABA YouTube channel There is a video on how to complete the forms for paper filing, and also videos on how to complete the forms online filing with My USCIS. So please check out those videos on the ABA Commission on Immigration YouTube channel for more specifics on how to answer those questions as they pertain to firm resettlement in the application itself. Another potential issue is dual nationality. Dual nationality is not necessarily a bar to TPS if the applicant can prove that they are, in fact, a national of Afghanistan. Just because they have another nationality doesn't necessarily bar them from seeking TPS. It might cause their application to undergo a bit more scrutiny. There might be an analysis of what if they spent significant time in their other country where they're a national, if they were able to live there, if they were able to have status there. But then some of the factors that we discussed under firm resettlement can also go into that analysis to determine the dual nationality piece. But if someone has dual nationality, then what will be considered is what passport did that individual use when arriving in the United States? Did they hold themselves out to be an Afghan citizen, or did they hold themselves out to be a citizen of the other country where they have nationality? If they've applied for immigration benefits in the past, what country did they claim as their country of nationality when they applied for those other benefits? And generally speaking, if someone is an Afghan national who was living in Afghanistan immediately prior to coming to the US, fled from Afghanistan, came here on an Afghan passport, is holding themselves out as an Afghan national, just because they have another nationality would not preclude them from being able to obtain TPS. Now, another important consideration to review is TRIG. TRIG stands for the Terrorism-Related Inadmissibility Grounds. So there are certain grounds that I discussed that are mandatory bars to asylum, including whether someone has engaged in terrorist activity or incited terrorist activity. The bars also consider if someone's a representative of a terrorist organization, a member of a designated terrorist group, and whether there are grounds to believe that this person has engaged in terrorist activity or is likely to engage in terrorist activity after entering the United States. Those are our TRIG grounds. The terrorism-related inadmissibility grounds are referred to as TRIG. And these TRIG issues are of particular importance for many Afghans because many of them at some point came into contact with terrorist organizations in Afghanistan, such as the Taliban, as a result of their work with the US government in Afghanistan. So TRIG issues really are not uncommon for Afghan applicants. And because of this, because of the prevalence of TRIG issues for this population, in June of 2022, the Department of Homeland Security and Department of State granted specific TRIG exemptions for qualifying Afghan nationals. And these TRIG exemptions provide exemptions for certain situational exemptions to cover activities that might be otherwise deemed associated with designated terrorist organizations like the Taliban. So basically, these are some carve-outs for situations that might otherwise receive a bar to TPS because of association with the Taliban. But because of these exemptions developed by the US government, Afghan TPS seekers can get around some of the TRIG bar issues. So what are the exemptions? There are 3 exemptions. One of them is on this slide. It's an exemption for Afghan civil servants. These civil servants must have been employed from September 27th of 1996 during the window of September 27, 96 through December 22nd, 2001, or any time after August 15th of 2021. And it includes teachers, professors, postal workers, doctors, or engineers, but does not include high-level government positions or work with certain ministries or people who directly assisted violent Taliban activities or were motivated by their allegiance to the Taliban. So this group is a possible exemption, but in this limited way, it doesn't include, as it says, all positions or all activities. it's limited to teachers, professors, postal workers, doctors, engineers, as civil servants. Two other exemptions for TRIG. Exemption number 2 includes Afghan allies. And Afghan allies are those who fought or supported those who fought in the resistance movement against the Taliban, or in the conflict against the Soviet Union. This group does not include people who targeted non-combatants or US interests, people who committed human rights violations or abuses, or people who acted on behalf of a designated terrorist organization. And then the third exemption category is for people who provided insignificant or limited material support. For example, instances where support provided to the terrorist organization was incidental to a routine social or commercial transaction, or incidental to certain humanitarian assistance, or provided in response to a reasonably perceived threat of physical or economic harm, and ultimately is considered minimal and inconsequential. So an example here is someone who was forced to stop at a checkpoint by the Taliban and perhaps pay money to the Taliban at that checkpoint. Yes, technically they're providing financial support to the Taliban by paying them at this checkpoint, but really that's an insignificant limited material support that is something that's kind of incidental to routine life and provided in response to a reasonably perceived threat for what might happen if they don't make that payment at a checkpoint. So those are the Afghan TRIG exemptions, which are good to know about. Again, in the other videos we have on Afghan TPS, we have an Afghan 201 video that goes more in depth on TRIG and other complex legal issues facing Afghan TPS seekers. It's also available on the ABA Commission on Immigration YouTube site, and that video discusses TRIG in more detail, as well as our videos that discuss how to specifically answer questions on the TPS forms pertaining to potential TRIG issues. Next, we're going to move on to employment authorization and filing fees. For filing fees, there's a table here that shows the cost of filing for TPS. The cost is not insignificant when you include the cost of an employment authorization document. So the I-821, which is the TPS application, is a $50 fee. And there are biometric services that go along with that, and then employment authorization documents are expensive, $410 for the initial application for an EAD. That fee only applies to those who are in between the ages of 14 and 65 for that EAD fee. But the total amount for people within that category, which is the majority of people we will be seeing between ages 14 and 65, the total amount, including an EAD, is $545. That can be a financial hardship for many TPS seekers, but it is recommended that if at all possible for them to pay the fee, that is recommended as opposed to filing for a fee waiver, requesting a fee waiver. Now, a fee waiver request is possible. There's a form called the Form I-912 that is a fee waiver request that someone could submit if they don't have the money to pay these filing fees. But processing times are delayed when an applicant requests a fee waiver. And if the waiver is ultimately denied, then the applicant must file for TPS again. They have to start from the beginning of the process, which can really significantly slow things down. So it is recommended that if they can get the money together, it makes the process much faster if the fees can be paid without the need for a fee waiver. So some considerations for an employment authorization document, which is Form I-765. Should someone apply for employment authorization? What are the circumstances where this might be beneficial or not? As you saw on the chart before, for applicants who are younger than 14 or over 65, the EAD is free. So for those applicants, it makes sense for them to go ahead and apply. Now, why would they apply if they have no intention of working? A 5-year-old child, for example, why would that person want an employment authorization document? It's because a TPS holder can receive a social security number and can use their employment authorization document as a form of identification. So through the EAD application, you can also request a Social Security card as part of the application. There's a certain section where you click yes and answer relevant questions, and that can then lead to identification and a Social Security number. So it's recommended even if someone isn't planning to work, and especially for those categories where it's free, might as well take advantage of that and go ahead and get those identification documents. It's also important to note that a TPS holder can obtain a new employment authorization document, even if they already have an EAD based on another immigration status. So even if they have an EAD based on one current status, they can get a new one under TPS and file for an EAD with a different code on the EAD that shows it's linked to their TPS status rather than whatever other status they might have. And applicants are going to want to consider whether it's worth their money to apply for a TPS EAD, also given their other EAD, based on when the other one expires, if that other EAD is renewable, how long a renewal would be valid, et cetera. Those are some considerations to think through. And again, in our TPS 201 video, which covers complex legal issues for Afghans, there's a more in-depth analysis of employment authorization documents, the pros and cons, and when to file. So in sum, with everything that I've just discussed, here's our checklist for filing for TPS. First, we need the form, the I-821, which is the application for TPS. And then there's a number of optional documents. It's optional to also file for an employment authorization document with the TPS category. You can include the waiver of inadmissibility if one of those inadmissibility grounds that I mentioned apply, one of the waivable inadmissibility grounds apply, then you can submit an I-601. There is the optional I-912, which is a request for a fee waiver, or you submit the filing fee. And then there's also an optional I-131, which is a travel document for advanced parole for someone who wants to leave the United States while maintaining their TPS status. Those are the potential forms that would be filed. And along with those forms, you can submit an optional cover letter. I say the cover letter is optional, but it's really strongly recommended. It's not required, but it is strongly recommended because the cover letter serves as a checklist in a way to orient USCIS to what documents are included in the packet that is being submitted. Because in addition to the forms, there's also the proof of eligibility that needs to be included. So as we discussed, proof of nationality, such as a passport or birth certificate showing nationality, proof of continuous residence, showing that someone has established residence in the United States. Those are monthly rent agreement, lease agreement, utilities being paid, hospital records, school records, those sorts of things that establish residence in the United States. And then our proof of continuous physical presence, which shows the date that someone arrived in the US, their passport stamp or I-94 entry document, or immigration court documents that reference the date they arrived in the United States to show that they were here before the CPP requirement in this designation. So the cover letter helps keep that evidence organized and explain to USCIS exactly what's in the evidence packet. And then also 2 passport style photos need to be submitted along with the application. What are some other considerations that are important to note before we conclude our training today? The first is a general note about processing times. It takes about 6 weeks to get a receipt notice after filing for TPS, and then a notice for biometrics will be scheduled, and that will arrive a few weeks later. Biometrics is an appointment where the TPS seeker needs to go to a USCIS field office to have their fingerprints taken and a photograph taken, and other biometric data is collected that is then part of their application process. It's important to remember that TPS is only valid for the 18-month period. For Afghanistan, USCIS has not yet released the current processing time for initial TPS applications, but processing times are delayed. So that's something to consider when considering timing for applying for TPS, is that it can take a long time to receive status, and it's a short-term status. So keep that in mind in terms of the expediency with applying. The impact of TPS on other immigration statuses. I mentioned earlier in the training that a person may have TPS plus another immigration status, such as a B2 tourist visa or an F1 student visa. But to maintain the other status while also holding TPS, they need to continue to be eligible for both statuses. So it's very important that, that they are aware of the different requirements for all of their different statuses and that they comply with those requirements. One important note, someone could receive an EAD through TPS, and that would make them technically authorized to work, but they need to consider whether the practice of actually working would violate the terms of their other visa, which might have limitations on employment. So they might have a status that says that they're not allowed to work and has limitations on them being able to work. And then if they apply for a TPS and an employment authorization document that says they can work under TPS, actually working might harm their other status and make them no longer eligible for that other status. So it's very important that they consider all of their different statuses and the restrictions on each and consult with an immigration attorney for advice where needed. A quick note on TPS and asylum. It is definitely possible to have both TPS and asylum, to seek both simultaneously or to be seeking TPS while an asylum application is pending. One important thing to note for affirmative asylum seekers, and those are people who are seeking asylum before USCIS and are not actually in immigration removal proceedings yet, but they are affirmatively asking for asylum, even though they're not facing removal from the US. For those people, if they are granted TPS and then their asylum application is denied in the asylum office, they will generally not be placed in removal proceedings. So to understand that, it's important to know that when someone seeks affirmative asylum before USCIS and there's no TPS involved, someone seeking affirmative asylum at USCIS, if their asylum application is denied, then they are referred to immigration court, removal proceedings, and they will have a trial before an immigration judge, and they have another chance to seek asylum in immigration court. And if they're denied there, then they would be facing deportation. For someone who has TPS, if they do not win asylum in the affirmative asylum posture, they will not be referred to immigration court because they have another legal status, so the TPS status, so they won't get that referral to immigration court. Now, is this a good thing or a bad thing? It really depends on the individual's facts and circumstances. If they have a weak asylum claim and most likely would not be successful in immigration court, then this could be a benefit for them because they have TPS status and they are not getting referred to immigration court. So they're not entering into removal proceedings, and they just hope that TPS keeps getting extended and redesignated, and that they can just keep renewing that TPS status over and over. But for someone who has a really strong asylum case, who thinks that the asylum office just got it wrong and they want the second bite of the apple before immigration court to show why they should have asylum, which is a more permanent status than TPS, then this kind of limbo could be a challenge for them. So again, it's just a consideration to be aware of, and people seeking TPS should confer with immigration attorneys about the pros and cons and timing of when to file, if this concern applies for them. If someone is already in removal proceedings and their case is already being heard in a defensive asylum posture, meaning that they have court dates, they're showing up before an immigration judge, they're already in removal proceedings, then they can advise the court of their TPS status, and they can seek prosecutorial discretion, asking that their case is either administratively closed or dismissed in removal proceedings, so that they can just focus on their TPS claim through USCIS and have their case dismissed or paused in immigration court, so that they're no longer moving forward with the removal case while they have their TPS status. We do have another training on our ABA Commission on Immigration YouTube channel that does a deeper dive into TPS and removal proceedings. So I recommend you watch that if you have further questions about how TPS impacts people who are in immigration court are part of the removal proceedings process. Now to conclude our presentation, we'll discuss a few FAQs. One is, am I eligible for TPS if I have a removal order? Yes, someone who has TPS, if they receive TPS, it might actually prevent their detention and removal from the United States. They are eligible for TPS even if they have a removal order that's already in place. So it's best to consult with an immigration attorney in that circumstance, if possible, to see how a TPS application can help in that situation. Can I travel outside of the United States with TPS? If they have had their TPS status approved, a TPS holder may apply for an I-131 to have permission to travel outside of the United States. That's the advanced parole for urgent or emergency circumstances. And then the final question here, can I get a green card? Currently, no. Under current law, there's no pathway for a TPS holder to apply for a green card. They must be eligible for a green card another way through another status. TPS does not confer that benefit. There have been a few times throughout this training where I have mentioned it might be helpful to consult with an immigration attorney for various reasons. So here is a link to a couple of different attorney directories. Find an attorney directory. One is with the Immigration Advocate Network's legal directory, and also AILA's Immigration Lawyer Search. These are good resources to look for attorneys near you, for legal service providers that you can, if you're an attorney, a volunteer attorney who's helping someone with TPS and you don't have extensive knowledge in this area, you can refer an applicant that you're working with to these areas to find an immigration attorney to provide a more in-depth consultation for them. And that concludes our presentation today. I hope you found this helpful, and thank you for listening.